We believe that we can unlock an iPhone with our ass. We believe that medical science is a bunch of crap. We believe that Sir Isaac Newton doesn't know shit about physics. We believe that Celebrite sometimes makes up timestamps but still is the best in the business. We believe that it is acceptable to rehome your family pet of 7 years. We believe that when we are harassed, that's the only time we shed real tears. We believe that we love John O'Keefe, but our group chat showed no compassion. We believe that sometimes you slip on ice and land on your knuckles. Don't you hate when that happens? We believe in providing law enforcement with specific text strings that make us look good and then destroying the ever-loving shit out of our phones. I'm not done. And then taking that destroyed phone and dumping it on a military base. Totally normal. We believe in manipulating people when they are most vulnerable. We believe we have to tell each other what to say to Channel 4, even though it's supposedly the truth. We believe that you're dumb enough to believe that John's injuries came from an SUV. We believe that if we put a billboard up, we can shift the narrative and point the finger back at the woman who was acquitted twice. We believe in disgracing the memory of a law enforcement officer and turning his tragic death into the biggest spectacle. Now shut up, look the other way and give us money! Sincerely yours, the House Defendants.
There was no collision. There was no collision. There was no collision.
So that's all to be reconstructed, with experts, and you can imagine how many hundreds of thousands of dollars that may cost just those experts alone.
It may not be just like ARCA. It may be ARCA. We'll see. We'll see.
I'll tell you who it won't be.
Who's that?
Aperture.
Oh, Christ Almighty!
That I know it won't be.
No, it will. It will not be. It will not be Aperture. Bless their little hearts. No, they're not going to. No. Yeah. John O'Keefe did not die from being hit by a vehicle. Period. The facts will show that. The evidence will show that. The data will show that. The science will show that, and the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. What are we looking at in this series of photos?
So these are photographs depicting, the test clothing. Again, prior to the test, there were no holes or damage to the sweatshirt. That was the same post-test. We did not see any observations with respect to any fraying, holes, punctures to the material of the sleeve.
Was there any damage whatsoever observed on the right sleeve of that ATD?
No.
Can you play that one more time, please? And what is this?
This depicts the post-impact damage to the rear of the Lexus. As I noted, the rear window is completely shattered. There's deformation and crush to the liftgate section of the vehicle. The bumper step was popped out, and then there was some minor fracturing in the bumper cover at the lower level.
Did you note anything regarding the internal components of the exemplar taillight? Even if this direct impact?
So the taillight, as you can see, it blew out the outer lens cover. I believe the part of the clear diffusers were actually still in place. I think the lower one might have been fractured here, but I think the upper one was still in place.
More or less damage in this photo to the diffuser specifically than in the subject taillight?
Well, I think there was more in the subject taillight. As I mentioned, I believe the top diffuser
more
on this
damage?
was correct.
Okay, that was my question.
Are you talking about frozen grass or paved?
I'm talking about Randy right now. These holes in the clothes are what you would expect after Randy hits the hard ground, correct? You've done no studies on hard ground, like a front yard, have you?
In terms of a pedestrian sliding on the grass?
In clothing tears, yes.
No, sir.
Trying not to
And if you
look
could
at
go back one slide.
him. Trying so hard. Randy is mangled. Can we just say for what it is? Randy is actually mangled. You can't even make this up.
It really is like Monty Python. Pite?
Waiting for the knight to come out with a shrubbery and a sword.
But you got no heart to know that.
Yeah, 'tis only a flesh wound.
Were you aware in your review of the police reports that none of the plastic that you were shown was found at the time John O'Keefe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
Dr. Retrial, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass,
Yes.
about a drinking straw.
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred. If the injuries don't match up, if you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Sustained, you have to watch the film.
Of course. In your expert opinion, based on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John O'Keefe?
I do.
Yeah, I'm sustaining that. You almost got it.
In your view, was there evidence of a collision with John O'Keefe?
Sustained.
In your opinion, were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it, to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine.
look, you look at the prosecutor in the first trial, Adam Lally, and then the second one, Hank Brennan. I mean, you have to think these are reasonably intelligent people. So what are they? They know what they're up against. They know the cards they're holding.
They're there to win.
They're there just to get a win for the state
That's
and for
it.
law. That's it.
That's it.
Doesn't matter if that girl
they
spends
had-
20 years in jail.
If they
50.
had any other view of this, they could not morally have prosecuted this case. If they had any other view other than, I just want a scalp.
What would you
just
have done
want
if
to
you
win.
were the prosecutor and they said, hey, Jackson, we need you to prosecute this case? Would you have looked at it and said, yeah, not doing it?
Absolutely.
Really? They can do
I wouldn't
that.
have
They
just
can
said,
say no.
I wouldn't have just said, yeah, I'm not doing it. I would have said, this needs to be dismissed. And if you don't dismiss it, I'm going to dismiss it and I'll quit before I stay in an office that will prosecute this case. It was bullshit, and they knew it from the beginning. Both Adam Lally, I don't give him a single pass. Do I think he woke up in the morning deciding he was going to frame Karen? No, I don't think Adam Lally is of that ilk. But he absolutely knew well enough to know that this was not provable beyond a reasonable doubt, beyond any and all reasonable doubt. Walk away. That is your job as a prosecutor. You are not supposed to prosecute a case that you don't, in your heart of hearts, believe that you can prove to an independent jury of 12 folks beyond a reasonable doubt. There's no way he woke up in the morning or went to bed at night thinking that he could prove this case, nor could Brennan.
These are morally compromised people.
100%. If anything Mr. Brennan just said was true, he might have an argument. My goodness. It's important to get some of the facts right. You got to get some of them right. The conversation that he just referenced with Jen McCabe was the next day. It was the next morning. Not minutes before the collision. He's read the every time he stands up, he says, I've read I wasn't there, I've read the transcripts. We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found, after he didn't come home. I'm sorry, I just need to correct. I'm sorry, I was talking to my client real quick. I'm not quite done. This was during the time after 5:07, after the SUV leaves, we see One Meadows, and Jen McCabe and Kerry Roberts get together, and as they're looking for them, as they're looking for him and searching for him, that's the point at which they have the conversation about being some other woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact. The other issues concerning Karen Reed's statements about being upset, or in Gretchen Voss's words, were you pissed at him? It was in context of when. When were you upset with him? When he didn't come back out. When he didn't come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever, no evidence in the record. I want to make this as crystal clear as I can. No controverted evidence, no suspect, no evidence at all that John O'Keefe and Karen Reed had a single crossword that night before he ended up missing and she went home. Before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out. Zero. The only evidence that was propounded throughout that entire day was hours and hours earlier that morning, dealing with, did you feed the kids donuts? And yeah, I did. You know I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough to enrage anybody. It's ridiculous. And the evidence that it didn't enrage anybody is the fact that they ended up later that night together in a lovey-dovey environment. Getting along fine, getting along wonderfully. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative. He really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. And we're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, you know, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want
That
the...
October 24th, did that video come with the metadata?
No. No, it's just video. It's a video file.
There isn't even ordinary evidence. There is no evidence of jury tampering in this case.
Juror interference, which is what we called it. It's words matter. We've claimed that there's interference. He indicates that that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts that he very dramatically stated in just a second, because this is a fact-based inquiry, one that we asked for standing right over there at sidebar and didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers that are populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None. Zero. And he knows that. But in an effort to create an enemy where there isn't one, he acts like we've insulted the court officers, which we haven't. He also said that Lieutenant Fanning stood up here and gave basically a CD, a resume for him, and said, the greatest guy on the face of the earth. I don't know Lieutenant Fanning. I don't know if he knows Lieutenant Fanning. Not really the point. It's in the personality contest. He said that we identified somebody with an unassailable reputation. We identified him? We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen, when somebody else identified him. It wasn't us. And by the way, everything that we filed concerning this was under seal. We didn't disclose anything in any court document. It wasn't a public document, it was under seal. It appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day unidentified, how would this person know who the juror sitting in one of these seats was if she was at a private location? I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things? How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people, who was then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's the commander over operations that are attendant to the courts, the actual court's security, the personnel's security, the party's security, to whatever degree that is necessitated, but maybe most importantly, the juror's security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given.
It was reported in some news article that they're getting ready to file this defamation lawsuit before I even saw this filing. Now that I saw the filing, I can confirm it.
Right.
If this is accurate, of course, but I'm assuming it is that I just had one response. I've got 2 words.
I'll bet I know what they are. Yeah, do it. Do it. Knock yourself out. You
I
be
will
the best you can be. Yeah, I don't care.
All right.
An expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well, hang on.
You wouldn't be objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Mr. Brennan said, what if I called a Massachusetts State Police officer to say that this was the best investigation ever? I have 2 words. Do it. Do it. I'd love that. I'd love a shot at that.
So I said, let's take personal.
That's not an invective. That's not a personal shot at Mr. Brennan. I'm just saying, do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we're entitled to present a defense.
Who are you most looking forward to questioning out of all the bad apples?
Yes.
All of them. Jen McCabe?
Oh, I would relish the idea of having another conversation with Miss McCabe. Yeah.
I'm trying to break it down between you and Miss Roberts. You've discussed her perceptions and her memory of what happened, as well as, and separate and apart from, your memory and your perceptions, correct?
Correct.
So there have been circumstances in which you and Miss Roberts have compared, by definition, what she remembers versus what you remember, correct?
I wouldn't say compare.
Now let's move to what would you say in terms of what you've discussed and why?
I would say that we've both talked about what we've discussed, but it wasn't like a comparison. We weren't comparing anything.
You've talked about what you discussed. What does that mean? Talked about your testimony?
No, we've discussed what happened to that moment,
Right.
and in those moments. So, when I got a phone call, and that's my story. I got a phone call in the morning, and then Carrie can say, yeah, I got a phone call as well.
As you said, that's your story, correct?
Not my story. It's
Those
the
were
truth.
yours.
It's the truth.
Okay. So both of you were assisting in each other's memories, correct?
Yes.
I remember this, and you remember this, and okay, now I remember this, correct?
Yep.
Obviously, that would help influence your memory, going
Yes.
over the event with someone else, correct?
Yep.
So what's on that timeline, you would agree, is not completely independent, your memory. It's a combination of your memory and Jennifer McCabe's memory. Isn't that right?
Yes.
One of the first calls you made after being contacted by these other law enforcement officers from a different agency, one of the first calls you made was to Carrie Roberts. Is that right?
She was the first one.
That's what I'm asking. One of the first two calls you made, your husband,
Right.
come home, there's law enforcement outside my door, I'm guessing is what you said, correct?
I don't remember my exact words now, but I did ask him to come home, correct?
And
Yes.
Carrie Roberts.
Okay. Yes.
You wanted to let Miss Roberts know that you had been contacted by certain officers from a different agency, correct?
I was curious if they had already been to her.
That was my next
Oh,
question.
yeah.
You also wanted to find out have these law enforcement officers from this different agency contacted her, correct?
Yes, because typically if you
I
enter
guess
a
yes or no.
town, she's...
Miss McCabe, yes or no?
Oh, sorry, I was just trying to
That's
explain.
okay.
I'm sorry.
Is that why you contacted her, to find out if in fact they had contacted her before you? Yes or no?
Yes.
And you also wanted to find out what she told them, if she had been contacted by them, correct? That was your motive in calling her.
No.
So you just wanted to find out, had she been contacted, but
Yes.
if she had said yes, you weren't going to say, and what the hell did they say? What did they ask you?
Well, I can't say what I would have answered, what I would have asked her, but I know I was calling to see if they had been there. Yes, that was correct.
That was your intent.
I called to ask her if they had been there. Yes.
So that was your intent, yes?
Yes.
Okay. Your motive in calling Carrie Roberts at that moment, before your interview, was to ensure that your story would line up with her story, Ms. McCabe. Isn't that right?
No, that is not.
You wanted to find out if she had talked to these particular law enforcement officers and what she had told them, so that your story could somehow align, or it could inform how you responded to questions that they asked you. Isn't that true?
That's not true. We both know what happened. We don't have to have a story. There is no story. There's what happened, and that's it.
So if that's true, Ms. McCabe, you have no reason to call Carrie and ask her if she had been contacted by these law enforcement agents, because it's just the truth, right?
We're going through this whole experience together. We call each other about everything. That's nothing more than that. I'm sorry.
Let her finish her answer. Go ahead, Ms. McCabe. You can finish that.
There's nothing more than me calling and saying, hey, did they come to your house? That's what we did when the media showed up, when Miss Reed's private investigator showed up. We just give each other the heads up, hey, somebody's coming. Because we're just like normal moms. We're not used to this.
And that's helpful in making sure that the stories she tells are consistent with the stories you tell to different law enforcement agencies, correct?
No, we are not telling stories.
So let her finish. You said no what?
I said, no, we're not telling stories. We don't have to compare.
And if in fact what you're telling is just the truth, there's no reason for you to inquire about who's contacted her when.
There's no inquiring. It's like when when the ice cream truck was at the street next door and I'm saying, did the ice cream truck come? It's really that simple.
So you asked a question, an argumentative question, and she responded in kind. Next question.
Thank you. The evidence will show that the evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, "I hit him." Not one. Not one civilian reported having heard Karen Reed say, "I hit him." The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert. Brian Albert's brother. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years-long close personal friends with a young woman named Caitlin Albert. You heard that right. It's Brian Albert's daughter. As a matter of fact, last year in this courtroom.
Yes, sir.
Okay. Did you look over your testimony at the grand jury 3 weeks ago during that meeting?
No, sir.
What about the testimony from last year?
We did go over the testimony from last year. Yes, sir.
Were there any issues that Mr. Brennan or anybody else in that meeting brought up concerning any of your testimony?
There was just a question of how many times the I hit him came up. It was 3 times.
And were you advised that that's not what you said at your testimony last year?
No, sir.
2 times?
What was that?
You said it was 2 times last year?
I honestly can't recall, sir.
Okay, but you just saw that, or you just read that and went over that 3 weeks ago.
I believe so, sir, yeah.
But you can't remember, as you sit here today, just 3 weeks ago, what y'all discussed in terms of how many times you previously testified that you heard the phrase, "I hit him."
So previously testified possibly to 2, but it was 3.
Okay, your memory is clearer now than it was, for instance, a year ago when you testified.
Repeat that?
Sure. Your memory is clearer now, as you sit here, that it was 3 times you heard that, than it was a year ago when you testified that it was 2 times.
Yes, sir.
Okay. Does your memory get better with time generally? Your memory. I'm not talking about the royal you. I'm talking about you.
In certain settings, I mean, there are certain things about different aspects that I recall better than others.
Okay. And does your memory tend to get better, or does it fade over time? That's my question.
It can fade over time, but it depends on the context.
But in this case, you're telling this jury that your memory is better now than it was a year ago when you testified about the exact same circumstance, correct?
Yes, sir.
Okay. You claimed on direct examination today, as a matter of fact, that Miss Reed looked at you at the scene and said the phrase, "I hit him, I hit him, I hit him." She said it 3 times, very distinctly, according to your testimony, correct?
She did, yes.
It was so impactful that it had the effect of putting you in some sort of shock and horror. Is that right?
I was in shock the whole morning, but that statement definitely was a lot.
You then met about a week after that, which would be 2 weeks ago.
Yes, sir.
Who'd you meet with then?
The same group.
And what did you discuss at that meeting?
Again, just prior testimony, and that was really the gist of it.
And tell me the specifics of the prior testimony that you...
Again, it was the how many times we had talked about saying I hit him, I hit him. Again, it was 3 times. And then there was also the video that was just played for me.
If I'll take the video in just a second. If y'all had met 3 weeks ago and you indicated to Mr. Brennan that it was actually 3 times, not 2 times that you heard the "I hit him," why did you need to discuss it again a week later to verify the 3 times versus 2 times?
Not sure, sir. That was just the way that the conversation went. And I just, again, repeated what I said and what I remember from that morning.
Well, tell me about that conversation. Did Mr. Brennan say anything like, well, are you really sure that she said it 3 times?
It was that morning what was said to you. And I said, I hit him. That was how it went that morning, and that was how I remember it.
Okay. And did Mr. Brennan say, well, that's not consistent with how you've testified previously concerning the number of times you heard the "I hit him" phrase?
Yes, sir.
He did say that.
He wanted to. He acknowledged that I had said it twice. However, again, as I mentioned, it was said 3 times to me.
And that's an incredibly memorable statement for you to have heard and now recount to us in this trial, correct?
Correct.
Something that you wouldn't easily forget or overlook. Is that right?
Something I wouldn't.
Something you would not easily forget or overlook. Is that right?
Correct, yes.
As a matter of fact, some might say it's the centerpiece of your testimony.
Objection. Sustained.
Ms. McCabe, you testified at a grand jury in April of 2022, did you not?
I did, yes.
Before you testified, you took an oath, very much like the oath that you took before you testified in this case, correct?
Correct.
You swore to tell the truth, the whole truth, and nothing but the truth, so help you God, correct?
Correct.
And that included the whole truth at the state grand jury, correct?
Correct.
That was only weeks, several weeks, but weeks after this incident, right? April 26th versus January 29th, 2022. Is that right?
Correct, yes.
Things were much fresher in your mind then than they are now.
I wouldn't necessarily say that.
Especially something as momentous as an admission from my client that she hit him. Would you agree?
Would I agree that she said that?
Would you agree that that would be fresh in your mind? Something as momentous as that. You wouldn't forget that.
I'll never forget it.
You wouldn't overlook that.
I will never forget it.
You would not overlook that either, would you, Ms. McCabe?
I answer the questions I'm asked.
Can you answer the question that I just asked? You're not answer my question. So now you do remember last year that you only said it, you only said that it was repeated twice.
One more time, sir.
So now you do recall that last year when you testified, it was inconsistent with how you're testifying today. Let me put it that way, correct?
I believe I said I hit him twice on the stand last year.
Right. And if you're saying I hit him 3 times instead of twice, that, firefighter Nuttall, is inconsistent with your testimony today, correct? You
yes,
agree
sir,
with that?
But that is how it went that morning, though, sir.
Okay, that's not my question. Let me see if I can do it again. So I'm asking you, if you testified last year,
yes, sir,
that you heard the phrase twice, and now a year goes by and you're testifying in front of this jury this year that you heard it 3 times, those 2 statements are inconsistent with one another, correct?
Yes, sir.
Okay. Did you talk at the meeting 2 weeks ago about any other inconsistencies with your testimony?
Not to my knowledge, sir.
Well, you were there. You say not to my knowledge, meaning?
No, sir, we did not.
Okay. So it was just about the number of times that you heard the phrase, I hit him, correct?
Yes, sir.
All right. You cleared that up in the 2 meetings, 3 weeks ago and 2 weeks ago. What did you talk about last night?
Mostly just making sure that everything was as it had been. I mean, and by that I mean it was 3 times, and that we were continuously making sure that everything was the way that it had happened that morning.
Everything was the way that Mr. Brennan wanted it to be.
No, sir. The way that it was in, I remember it and I recall it happening.
Okay. So he asked you 3 weeks ago about how many times you heard that phrase.
Yes, sir.
You changed your testimony at that time and said it was 3 times instead of 2 times. We agree on that, correct?
Yes, sir.
Then he called you a week later, or met with you a week later, and again reiterated, making sure you stick with that testimony that it's 3 times, not 2 times, correct?
Yes, sir.
And then last night he called you just to make sure one more time you're going to stick with that testimony that it was 3 times, not 2 times. Correct?
Yes, sir.
And the reason you wouldn't overlook it is because it was so impactful on you, having heard that. Not once, not twice, 3 times. I hit him, I hit him, I hit him. Is that right?
Yes.
May I approach?
Yes.
Thank you.
Take a look at that document and tell me if you recognize it.
Yes, I see it.
Is that a transcript of your entire grand jury in April of 2022?
I believe so, yes.
You've reviewed it in the past?
I have read it about a year ago, yes.
You read it in anticipation of your testimony a year ago, correct?
Yes, I reviewed it.
Have you reviewed it in preparation for your testimony today?
No, I haven't.
Yesterday. Ms. McCabe, turn to the page or pages in that transcript where you recount to the grand jurors that my client said, I hit him, I hit him, I hit him.
This is over 227 pages.
How long did you say it was, Ms. McCabe?
227?
I'm not going to let her read 227 pages.
You reviewed it before, haven't you?
I reviewed it a year ago, yes.
You read the whole thing cover to cover, didn't you?
I skimmed through it.
One of the most important points in your testimony yesterday and today is recounting these jurors the phrase, I hit him, I hit him, I hit him. Is that right?
Objection.
To the form of that, I'm sustaining it.
Was it important to you to tell these jurors that you heard my client say, I hit him 3 times?
I answered the questions and I'm telling the jurors what I know.
Was it important to you before testifying today that you recount to these jurors the phrase, I hit him, coming out of my client's mouth?
Your client said she hit him, yes.
That's not my question. Listen to my question, Ms. McCabe.
I'm sorry.
Was it important to you before you testified to tell these jurors under oath that my client said, I hit him 3 times?
As a juror, as a witness, it's important to tell the truth and to answer the question you were asked.
And in point of fact, in your entire grand jury testimony, you never said, my client said the words, I hit him, did you?
Again, it's 227 pages.
So now, after Mr. Brennan asks you a few questions, now you remember her saying, I hit him a bunch more times. Correct?
I remember hearing it in the background several other times.
Really?
Sir?
Never mentioned that on direct examination, did you?
I don't remember being asked about it, sir. I remember saying what was asked to me.
You were asked, did you ever hear the defendant, Ms. Reed, say anything about I hit him? And your answer was, she said to me, in answer to my question, I hit him, I hit him, I hit him 3 times, and that's it.
To me.
You didn't clarify that, oh my God, she's rolling around like a chicken with her head cut off, screaming I hit him to everybody else under the sun.
It was, again, it was behind me in the background as I was providing patient care. Again, that was not my focus.
Okay, so you didn't really hear her say anything in the background because you weren't focused on that, right?
I remember hearing a generalized commotion in the background, but again, that was not our focus.
So generalized commotion is very different than hearing her say, I hit him to other people, correct? You'd agree with that?
Yes, sir.
So what you actually heard was the chaos and the commotion of a chaotic scene, correct? In the background.
In the background.
As you focused on your patient care, correct?
Yes, sir.
Okay, not specific words coming out of my client's mouth, correct?
To the question that I posed, do you know him?
You're right. We're off that question.
Okay.
That question, I got it.
Yes, sir.
Triple I hit.
Correct.
But with regard to what Mr. Brennan just asked you, the generalized commotion, to use your phrase, in the background, you didn't hear any specific words coming out of my client's mouth, did you?
I heard I hit him, But again, it was in the background and it was not my focus.
Well, why didn't you say that on direct? That's kind of an important point. It's why you're here.
Again, if it was neglected on my part, it was not intentional.
Not intentional to neglect that part for the jurors on direct examination.
No, sir.
Certainly not intentional to neglect that part of your testimony on cross-examination.
No, sir.
But you decided to bring it up on on re-cross-examination when Mr. Brennan is asking you questions again, correct?
It was asked of me. Yes, sir.
And it was after, of course, that your new statement that you've never testified to before, ever, is this generalized commotion included a bunch of I hit him's in the background, correct?
Sir.
And that comes after you saw the video that clearly shows that when you describe having heard this statement, her client was nowhere around you, correct?
That segment of the video that you showed me?
Yes.
That was not the time frame in which she said that to me.
Well, that was the time frame when Flamati was giving CPR, correct?
He was doing CPR down prior to that as well.
Really? Ms. McCabe, you were there. They're your words. I'm not asking you to rehearse something. You were there. Did you tell the grand jurors that my client said I hit him?
I have testified a number of times, but I was there the morning of January 29th when your client said I hit him, I hit him, I hit him.
Did you tell that to the grand jurors?
I'm not sure.
It's because you didn't, did you?
Again, I'm not sure.
Ms. McCabe, you were asked in your grand jury testimony no fewer than a dozen times, 12 times, 12 separate times, you were asked to repeat words that my client said both before, going to, and at the scene at 34:30 that morning. Correct?
Objection. Do you know the answer to that?
No.
You were asked multiple times what my client's words were that you heard her say going to and at the scene. Correct?
I was correct.
And you recounted those words truthfully and honestly at that time. Correct?
Correct.
Because you were under the same oath that you under today.
Correct.
And things were much fresher in your mind then than they are now 3.5 years later. Would you agree with that?
I hit him, I hit him, I hit him is just as fresh today as it was 3 years ago.
Quote, so there are different, police officers getting statements from us. And at one point I'm standing with Miss Reed and she's saying, did I hit him? Could I have hit him? And there was, I believe, an EMT, a female, standing right next to me listening to her yelling, did I hit him? Could I have hit him? Is he dead? Is he dead? Is he dead? It was pretty nonstop, pretty much nonstop. That was your testimony in front of the grand jurors, correct?
Yes, it was.
And that was April 26th, 2022, correct?
Correct.
Not one time. Not one time, Ms. McCabe, did you utter the phrase, I hit him, as it relates to my client in front of that grand jury on April 26th, 2022, did you? Not once.
I'd have to read through the 227 pages to see.
As you sit here today, do you remember ever saying to those grand jurors, she said, I hit him, I hit him, I hit him, in front of a female EMT?
I've spoken to in a few grand juries. What I said specifically at different ones, I don't recall at this moment, but I do know that morning your client said, I hit him, I hit him, I hit him 3 times, and there was a female EMT there.
Well, I asked another question. Once we had come to a stop, I asked if there had been any significant trauma that happened that preceded this, and she answered with a series of statements that she repeated. I hit him. I hit him. There was a woman next to us who told her to calm down, stop talking, calm down, you're hysterical. So she repeated, I hit him, and a police officer asked her, said, you what? And she repeated it again, I hit him. And the officer then signaled for his sergeant to come down to the scene or down to where he was.
you're describing a situation in which you're standing there, Miss Reed is next to you, within earshot is a uniformed police officer, and she said, I hit him, correct?
Correct.
Then he said, what? Is that right?
So it's, I hit him. Miss McCabe interjected, and then she said, I hit him. And then the officer said, you what? And then she said, I hit him. And he said, go get Goody down here.
Okay, so is that 3 times or 4 times that you indicate she said I hit him?
4 times.
And you, according to you, you indicate that at the time that she made these statements, she was hysterical and somewhat out of control. Is that right?
She was upset. I would say hysterical, yeah.
Did you describe her last year as obviously upset, overly frantic, and almost hysterical?
Yeah, I believe it. I remember that.
Okay. Can you stop it? Did you see the 2 people enter from screen right?
Yes.
Who is that?
That would be myself and Miss Reed.
Okay, this is the first point at which you and Miss Reed begin to converge with the other 2 individuals, Miss McCabe and the officer, correct?
I had started trying to gather the information prior to this, and then she was moving around, so I had kind of was following her, asking the questions, and then we eventually came, here to this point and came to a stop.
So your answer is yes. This is the point at which you converged with Miss McCabe and the officer.
Yes.
Okay, thank you. Let's go ahead and play it. Pause it. You see yourself sort of in the foreground in a bright jacket?
Yep.
And Miss Reed's just on the other side of you, correct?
Yes.
Standing there.
Yes.
Okay. Who in that video, Miss Reed or Miss McCabe, appeared to be doing most of the talking?
You cannot see from that video.
Who in that video
I don't know.
appeared to be gesticulating with her arms? My client or Miss McCabe?
I think Miss McCabe was doing that, saying you need to calm down. You're hysterical.
Oh, the whole time she's gesticulating, she's saying, calm down, Karen, you're being hysterical. Calm down, you're hysterical. Just repeating that?
She was trying to get her to stop and to calm down because of the statement she was making.
I see.
And she was trying to get her to stop, calm down.
I see. Okay. So during that entire video, that was probably 40, 50 seconds or so, maybe it's a minute. That's when you're saying now that Miss McCabe was gesticulating and saying, calm down, Karen. You need to stop making statements. Calm down. Right? That's what she was doing.
Yes.
Okay. Well, you'll agree that Miss Reed was standing relatively quietly to your right, not saying much of anything.
No, what she had just said, she had seemed upset when she said that, and what she said was obviously Miss McCabe was trying to convince her that that was not, you need to calm down, stop saying that.
Right in front of a police officer who never said he heard her say it.
Objection.
Assistant.
You were standing 18 inches, 2 feet from Officer Sarah, correct?
I don't know exactly.
Well, give me an idea. I mean, 2
I-
feet, 3 feet, what?
He was standing near me.
And he was standing even closer to my client, wasn't he?
Yes.
At this moment, when you claim to have heard the "I hit him" repeated 4 times, where was Officer Flamati? I'm sorry, where's Firefighter Flamati and Firefighter Nuttall?
In the ambulance.
With the doors closed.
Yes.
Ms. McLaughlin, where are your notes regarding this statement?
I don't have any.
Where'd they go?
It's not in the role that I was in, I'm not in a position to write a report on this type of call. It would be the lead paramedic or the officer on scene.
So you didn't write anything down, you didn't have any opportunity to write anything down?
I didn't.
You were just going by your memory?
Yes.
What can play exhibit 4, starting runtime 8:50? I'd like you to pay special attention, Mr. McLaughlin, to your right and your left hands as this video plays. Could we go ahead and play it? What is it? What are you looking down at?
Oh, I see what you're saying. Yeah, I would write like stuff on my glove. That's something I'll do as I'm getting the information. Was that your question about notes?
So you were taking notes.
That's just me jotting down the demographics.
So you indicated that this is the point at which, and we can leave the lights down for a second. I'm going to play it again. This is the point at which you said my client had just said, I hit him. Basically confessing to having hit John O'Keefe, correct?
Those are the statements she'd made.
And Officer Seraph is standing right there, right?
Mm-hmm. Yes.
You see any reaction from him right there?
I know he turned and told somebody to go get the sergeant. I don't know if that already played. I'm sorry?
Did you see any reaction from him?
He responded, "You what?" And she repeated it again, and then he told someone to get the sergeant.
I know that's what your statement is. I know that's your testimony. I'm asking about the video. Do you see him reacting right here?
You'd have to play it again. I wasn't looking at that part.
Do you see him handcuff my client?
Oh, no.
You see him call anybody over to handcuff my client?
He turned to signal to get Goody down here is what.
So they handcuffed her?
No.
Right. They didn't handcuff her?
No.
Even though she just confessed in front of a police officer, according to you.
That's what she said.
I hit him. It's my fault. I did it. That's a confession, correct?
She said, I hit him.
And Officer Seraph just stands there, and my client walks away, correct?
You'd have to talk to Officer Seraph about that.
Oh, we have.
You should.
Mr. McLaughlin,
Okay, so let's move on. Mr. Jackson, I'm not rushing you, but how much longer do you think you'll be?
Not long.
Okay, so.
I can wrap it in a couple of minutes.
Okay.
Yes, I wrote down some of the things that were said.
Some of the things that were important, correct?
Yes.
For instance, you write down John O'Keefe. That's his name, right?
Right.
You might write down a circle with a slash through it. Allergies. No allergies, right?
Right.
You might write down 46 for his age.
Right.
You might write down how he was injured. Hit by a car, correct?
I did not know that was. Well, I didn't know what those statements meant.
You might write down 3 little syllables. It was just told to you. I hit him, especially if it had been repeated 4 times as you call it, correct?
Yeah, I had that in my head, and I was going to go tell them that.
And you had a pen right in your right hand, writing things, correct?
Yeah.
You never wrote that down.
I wasn't going to write that statement down on the glove. I remembered that, and I went back to the ambulance and told them.
You did memorialize that statement on any note that we have, correct?
No.
You didn't memorialize that statement on any glove that you were wearing, correct?
No.
Whatever you wrote down on that glove, where is that now?
Yeah, I don't have it, obviously.
I don't know how obvious it is. What'd you do with it?
You just scratch everything out and you throw out the glove.
Just threw it away.
Mm-hmm.
Is that right?
Yes.
Is that yes?
Yes.
So we don't know what was actually on or not on that glove, do we?
I didn't write those words down on that glove.
As we stand here, we don't know what was or wasn't on that glove.
Name, date of birth, no meds, no history, no allergies. And then I wasn't writing that statement down on the glove. I went back to the ambulance and just reported it.
And importantly, it was important enough, as you say, to go back and report the statement, but not important enough to write it down with that pen that was very conveniently in your right hand, correct?
It's not about importance. I was relaying that information to the ambulance verbally. I didn't need to write it down.
And you, in fact, didn't write it down, did you?
No, I didn't make a report about it.
And you're also aware that not a single police officer out at the scene wrote that down either.
Objection.
Sustained.
You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation, it's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel.
I got to play you one cut, though. I got to play you one cut as he goes over his investigative chops here. Cut 9.
Sure. Is there any part of the actual investigation that you would do over?
Because it's blown up into this crazy so-called conspiracy, maybe I could have avoided it by, looking at other people's cars just to say we did it. There's some witnesses maybe we could have interviewed a little sooner. But overall, myself and every detective in that office worked this case like we always do. So I wouldn't change anything.
Nothing.
No.
We work this case just like we always do.
That is the scariest phrase I think I've ever heard from a detective. Given what we now know about how this case was investigated and not investigated, for him to literally say on national TV, nah, not so much. I would work this case just the same way I'd work every other case, just like I do every other case. Every other defendant, every other defense attorney who has represented a defendant in which Michael Proctor has touched a piece of evidence should be clamoring for some sort of habeas corpus, some sort of retrial, some sort of redo, if you will, in Massachusetts. He is a disaster in terms of an investigator, an absolute abject disaster. For him to say, maybe I should have looked at another car, maybe I should have interviewed a couple of witnesses. Are you kidding? He acts like it's an afterthought. That is your job, sir. Do your job. Do your duty. You're supposed to be an objective finder of fact and then present those facts to a prosecutor who then presents those facts to a jury. None of that happened. None of what I just described happened. And that is day one in law school. That's day one. You learn that.
I want to talk to you for a second about roles in this case, in this investigation. Would you agree with me that Michael Proctor was the lead investigator as well as the case agent in charge of this case?
He was assigned as the case officer for the case.
In that position, given the fact that it was his assignment, would you agree with me that he had a leadership role insofar as the investigation of the case is concerned?
I wouldn't call it a leadership role. It's more of a facilitator, liaison between the DA's personnel within the office and the state police. He also helps facilitate any missions, outstanding tasks that need to be completed.
He obviously had a supervisor, correct?
I'm sorry, can you repeat that?
He obviously had a supervisor, correct?
He did, yes, that would be myself.
That would be you.
Yes.
Every case has some lead trooper in your unit, correct? Every case is assigned to someone to sort of be in charge and lead the charge of the investigation. Is that right?
Every case has a case officer that manages the investigation.
Right. And managing the investigation doesn't mean just, typing up schedules. It means actually managing the investigation, like deciding what search warrants are going to be written in certain circumstances. That's one example, correct?
They're responsible for writing and authoring those search warrants. Sometimes the recommendation, suggestion, or leadership comes from the supervisors or the DA staff, where their experience might dictate otherwise.
And sometimes it comes from the lead case agent himself or herself, correct?
At times, yes. The case officer for the investigation was Michael Proctor.
But you don't want to say lead case agent or case officer, correct?
I refer to that billet as case officer.
Your responsibility as the supervisor over this particular case officer or any other case officer that you might have, or any other trooper that you might have under your supervision, your responsibility in no small part is to supervise the individuals under your command to ensure that the case is adequately investigated, it's properly investigated. That's part of your role as a supervisor, correct?
Is one of my many responsibilities, yes.
As you sit here today, do you believe that this investigation, now I'm going to turn to this investigation, was conducted with professionalism, with competence, at the highest level of integrity?
This investigation was conducted professionally, with integrity, and all the evidence collected, all the statements collected, pointed in one direction. There was no bias influence on the evidence, on the information that was collected, or which direction the investigation pointed naturally.
Former Trooper Michael Proctor was the person who was the assigned case agent, the lead case agent in this particular investigation, correct?
Michael Proctor was the case officer for this investigation.
He was assigned, ultimately, to use another phrase, as the lead investigator, wasn't he?
I'm not going to agree with you.
Is there a reason that you want to try to distance yourself from naming Michael Proctor as the lead investigator in the case? Is there some reason?
I am not trying to distance myself. All I'm saying is the term that I use is the case officer. We're simply case managers. There's no leading investigation in any direction.
So, in your mind, well, let me ask you this. Is a case officer another word for that? Synonym would be an investigator, right? He's a detective, an investigator, right?
He is a detective, yes.
And he was the one who was assigned by the Massachusetts State Police because of his on-call status that night, that morning, January 29, 2022, he was assigned to the case, correct?
Michael...
Yes or no? Assigned to the case. That's all I'm asking.
Well, you said a lot before that, so...
I said he was assigned to the case. What I said before that was January 29, 2022, he was assigned by the Massachusetts State Police as the case officer for this case. Correct?
No.
Who was?
He was assigned to be on call a month prior. Just because he was on call, he was assigned the case as a result. He was not assigned the case right there and then, because his assignment began much earlier in the day.
So let me do this all day exposed. He was on call.
He was.
Correct?
He was.
Because he was on call, any case that happened to come in would be assigned to whom?
To the on-call trooper that's on the schedule.
Which was whom?
It was Michael Proctor.
Let me just ask you this. Do you believe that Michael Proctor, his involvement in this case, taints the investigation? Tainted the investigation?
No.
Not at all.
The investigation was done with honor, integrity, and all the evidence pointed in one direction only.
Honor and integrity by Michael Proctor?
Is that a question? I'm sorry.
Sure is. Everything I say is a question. Honor and integrity by Michael Proctor? Sergeant? Okay.
Sustain to the comment. Go ahead and ask it again, Mr.
I'll ask it again. You said honor and integrity. Honor and integrity by Michael Proctor? Objection.
I'll allow it.
The investigation was conducted with honor and integrity, and all the evidence pointed in one direction and one direction only.
So, Sergeant Bukhenik, you don't want to answer my question. Correct?
I will answer your question, absolutely.
Do you think this case was handled with honor and integrity by Michael Proctor, Sergeant?
The investigation was handled with integrity by Michael Proctor.
She's a whack job, CUNT. She's got a leaky balloon knot, leaks poo.
What, if anything, is that in reference to, sir?
Again, to misread some medical conditions there. Again, unprofessional comments I should not have made, and that I'm not proud of. I text my wife waiting to lock this whack job up.
Your response was, hopefully she kills herself, correct?
Yes. Figure of speech.
You wanted her to, the figure of speech is you wanted her to kill herself.
No.
Right?
No, it's not.
Then you decided to make a comment about Mr. Yannetti, her lawyer, correct?
Correct.
And what did you say about Mr. Yannetti again?
I hate that man. I truly hate that man.
I hate that man. I truly hate him, correct?
Correct.
Your response was, I'm going through his retarded client's phone right now, correct?
Yes, after the picture, sir, yes.
What did you write after you talked about going through the, quote, retarded client's phone?
Objection.
I'll allow it.
No nudes so far.
No nudes so far, correct?
Correct.
And you said that to your bosses.
Yes, sir.
The investigation was handled with integrity by Michael Proctor.
By not calling him, and I said this on my show, I go, this is the ballsiest decision ever, because if this woman is convicted of anything,
I gotta own it.
DUI, then you not only you gotta own it, that's gonna go down as the worst call ever. Like your Grady Little level, like keeping Pedro in the game. Like that's what that would go down as. Didn't that make you freaking nervous?
I say this a lot, and it sounds really self-aggrandizing. I don't get nervous. I make people nervous. I make decisions because they're the right decisions, and it comes from 30 plus years of decision making. And at some point, you got to have the balls to make the call. You got to make the call. I knew that in my heart of hearts, I knew that having an empty chair, having the ogre under the bridge, having and that's both Proctor and Higgins. I could make hay out of the fact that the Commonwealth didn't call two very, very obvious witnesses. How do you not call as the prosecution? How does Hank Brennan sit there with his suit on and his tie knotted and his glasses on, sitting there with his hair combed and his socks and his shoes and all his accoutrements, and stand up in front of the jury in closing argument and express to them a reasonable judgment why he didn't call the lead homicide investigator for the lead homicide that the jurors are expected to judge.
Well,
and I made him.
He wasn't the lead. He wasn't the lead, according to Mr. Bukhenik.
Yeah. And everybody in the courtroom except him knew that was bullshit. That was complete bullshit. So I was never gonna. My decision at the very beginning of the trial is, if they don't call Proctor, I'm not going to call Proctor.
So you decided early on.
Yeah, I was going to make them own it. They're going to own it.
Really? Okay.
They're going to have to own that. And it's a difficult ownership to have, not to call your lead investigator when the jurors are commissioned with the responsibility of judging the investigation. How do you not call the lead investigator? So from an ego standpoint, I would have loved to cross-examine Michael Proctor again. He stood no chance. As bad as it went for him the last time, it would have gone 10 times worse this time. You indicated that you were spitballing, to use your word, correct?
Correct.
Trying to figure out what happened.
Correct.
That's the job of an investigator, correct?
That is correct,
You
yes,
don't just take witnesses' words for things, do you?
That is correct.
You have to corroborate things.
Yes.
You have to look deeper.
Yes.
Ask more questions.
Absolutely.
Actually investigate.
That's why we're here today.
You don't rule out anything or anyone right off the bat, correct?
Correct.
No one is ruled out. Nothing is ruled out. Correct?
That is correct. Yes.
You follow where the evidence leads you. Period. Amen.
Absolutely.
You didn't seek. You didn't seek to separate the occupants at 34 Fairview. Correct?
No.
You didn't interview Brian Albert formally, did you?
I did not. No.
You were asked by Mr. Brennan, did he ever end the conversation precipitously? Did he end it early or anything like that? He didn't end any interview because he wasn't interviewed, correct?
That is correct.
You didn't interview Brian Higgins.
That is correct.
You wouldn't interview Brian Higgins because he's your personal friend, correct?
Correct.
But you didn't have anybody else interview him either, did you?
Again, we're talking, I think we've gone over this and maybe you didn't understand it. I didn't know Brian Higgins was at the house at that time.
Because you didn't ask anybody else who was at the house at that time.
I wasn't talking to anybody at that house, correct?
Might have been a good idea, wouldn't it?
Not at that time. We were there for one specific reason. We wanted to get to the hospital. So no.
Might have been a
I
good
disagree.
idea to sit Mr. Albert down and say, there, you're shaking your head again. I'm not done with my question. Might have been a good idea, Mr. Gallagher, since you happen to be there, no sweat off your brow, to sit Mr. Albert down and say, by the way, I got a pen and paper. Who was here last night, just before John O'Keefe was found dead on your lawn? Who was here? Might have been a good idea, correct?
So that was already done by Detective Sergeant Lang, and it was documented in his report of everybody of what Mr. Jackson is asking.
Then how did you two not know that Brian Higgins was there?
I don't know where. I'm confused. At what time?
Right.
At what time?
Exactly.
At what time?
When John O'Keefe arrived.
Okay.
At 34 Fairview after midnight on January 29th, 2022.
So when I discovered Brian Higgins was there, wasn't until I read the report.
If you were standing in the house, Sergeant Lang, you just told these jurors knew that Brian Higgins and everybody else was there.
He had obtained the names. He hadn't written the report yet.
I hadn't told his boss.
I don't recall.
Even though you two went together to interview yet another witness?
That's correct. There was a very fast-moving scene and pace. That is correct.
You don't get in trouble or get spanked or get slapped or get fined if you seek a search warrant that is denied, correct?
In this particular situation, I would need to articulate facts, certain circumstances, and witness statements. What I had was nobody could put John O'Keefe in the house, including Miss Reed, and that we had a glass where they were coming from a bar, and I had 3 separate police officers, including myself, that had been in that house on 3 separate occasions and saw nothing amiss. I have a good faith obligation to present the truth to a judge, and if I don't, I can be found, end up on a Brady list or a Giglio list, as you know, and my credibility to testify in my career is basically over. So yes, you can get in trouble.
You're talking about lying in an affidavit, sir.
I'm talking about misleading.
Correct.
I would have to twist circumstances to have the right to search Brian Albert's house. We had no reason, and there's been no reason since.
How about this? There's a dead guy on the lawn that looked like he potentially could have been in a physical altercation. How about that? Might that be of some concern to go inside the house and see if there was a struggle started in the house?
There's still no evidence to go into the house.
You're a guy that's out on the lawn with no coat on. You think the coat might be inside the house? That might be a reasonable assumption? Yes or no?
No.
You're a guy outside with no shoe on. You think the shoe might be inside the house? That might be a reasonable assumption?
I never saw Mr. O'Keefe. I wasn't aware that he
because you didn't
had his
seek
shoes
to find out the details. Other people knew every single fact that I just suggested at the time you walked in the house, correct?
Objection. Sustained.
The fact is you didn't seek a search warrant.
I wouldn't. Correct.
The fact is you never searched the house.
That's correct.
The fact is you never searched the basement.
That's correct.
The fact is you never searched the garage.
That's correct.
That's all I have, Your Honor. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe. She was at the waterfall that night, and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence, from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools, you'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us. But we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now, she misspelled the first word. Hos is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. What application did you open up on your phone once you got upstairs?
It could have been Hockomock Sports.
I'm sorry, I'm backing up foundationally. What application on the phone? Was it Safari?
Oh, okay, yes. I think, yes.
You use Safari as your browser?
I'm not sure what I used.
You opened up a search engine as well within that browser, did you not?
I just know I Googled Hockomock Sports, I believe. I'm not sure what app I opened or how I went about it.
So Google is a search engine. You use Google.
Possibly. I mean, that's just an expression, but I'm not, if you could show my record, I'm not sure what app I opened.
Well,
or
Ms.
what.
McCabe, you've seen this record many, many times about that search early in the morning hours, correct? You know that it was a Google search.
It was Google. Okay, it was a Google search.
Okay, so it was a Google search using the Safari app.
Okay.
You indicated that you were Google searching Hockomock Sports and something about Ozone?
Yes.
Ozone Sports or Ozone Basketball?
Yes.
What time was it that you did that Google search?
It was when I was home up in bed. I don't have an exact time.
About 2:27 a.m., correct?
I'd have to look at a record. I don't recall off the top of my head.
You certainly recall that time frame, don't you?
I know I was home and I Googled that, but I don't remember the exact time.
You do recognize 2:27 a.m.
I do recognize it, but it's not from me remembering it from that night specifically. It's from me learning afterwards.
And what you learned afterwards was there was a Google search at 2:27 a.m., right? I mean, that's a layup, to use a basketball term, right?
There's a record, I think, of one.
Right. The record is of a Google search at 2:27 a.m. on your phone. Is that right?
I'm not a phone expert, so I don't know. I can't read.
You're well aware. You don't have to be a phone expert to know that there was a Google search on your phone recovered at 2:27 in the morning. You know that. You've been told that. You've seen it. You've been asked about it dozens of times, haven't you?
I have been asked about it dozens of times, yes.
So let's set the foundation. There was a Google search on your phone at 2:27 a.m., correct?
Which Google search are you referring to?
It doesn't matter, Ms. McCabe.
Well, I know I did Ozone and I did Hockomock Sports.
And I didn't ask you
those
that.
were the only two things that I Googled.
I didn't ask you what you Googled. I haven't gotten there yet. We're going to get there. I've asked you, was there a Google search at 2:27 a.m. on your phone?
If you want to show me a report.
Sure.
Okay.
You don't know, as you say, that you don't know that.
I don't.
You have no record. You have nothing in your mind about a Google search at 2:27 a.m. That's what you're testifying to in front of this jury right now.
Are you asking me if I made a Google search at 2:27? I don't know what time I was searching for Hockomock Sports and Ozone. I have no idea what time that was.
You're well aware that your records have been pulled, correct?
Yes, they have.
You've been confronted with those records many times, haven't you?
I've been asked by you, yes.
And by others, right?
Yes.
I mean, the police have asked you about it. You've been interviewed about it.
I've been asked by you.
And Mr. Lally?
Yeah, Mr. Lally asked about it, yes.
And every time you're asked, it's about a Google search at 2:27 a.m. That's all I'm asking.
It is, but it's not one that I remember doing or making or did. It's not one I did. It's just one that is in a record that was misread.
Are you denying that you made a Google search at 2:27 a.m.?
If you could show me this Google search, I'd appreciate it.
Have you and Carrie Roberts ever discussed the fact that she corroborated your statement that Karen Reed demanded that you Google hypothermia?
No.
She ever told you that?
No.
Did you ever ask her that?
No.
Did you discuss your statement that Karen Reed was the one that demanded that search?
Karen Reed did ask me to do the search, yes.
Okay, that's not what I asked you. Did you and Carrie Roberts discuss that?
Yes, we've talked about that.
Are you aware that last week Carrie Roberts denied hearing that statement?
Sustained.
Have you been told, have you been updated that last week Carrie Roberts denied ever having heard that statement?
Sustained.
May we approach?
Yes. So just one question on this. Just one question on this, please, Mr. Judge.
Have you become aware from any source that last week Carrie Roberts denied having heard the statement that was attributable to my client?
No.
You read that?
No.
Were you interviewed by a different law enforcement agency, a separate law enforcement agency from the Massachusetts State Police at any time?
Yes.
And you were told that to lie to those agents would be a crime, correct?
Yes.
Punishable by prison, correct?
I was not told that.
They asked you whether or not you heard Karen Reed ever say anything to Jennifer McCabe about Googling anything, correct?
I don't know.
Isn't it true that you told them what you've just now told us, which is, I did not hear Karen Reed ask Jennifer McCabe to conduct any Google searches?
I don't recall.
And what you told them was, you, quote, did not hear Karen Reed ask Jennifer McCabe to conduct any Google
That
search.
is correct.
And you went on to say, you saw McCabe on her phone.
I'll allow it.
You saw McCabe on her phone, but you did not hear Karen ask Jennifer to Google anything.
Correct.
So what you told the grand jurors was in fact false.
I misunderstood Mr. Lally's question.
Got it. Thank you, Your Honor.
Okay.
You've reviewed the video from the dash cam out at the scene, correct?
I've seen it, yes.
You're aware that there is no video showing my client demanding a Google search anywhere in this case, correct?
I'm not sure what what cameras were where.
You're aware that there's no audio of my client demanding a Google search, correct?
Correct.
You're unaware of any witness who can corroborate your statement that my client demanded a Google search. Any witness at all.
It was just the two of us. She had sent Carrie off.
So, of course, Carrie Roberts is not such corroborating witness. Is that right? At least you understand that.
Can you rephrase the question, please?
Carrie Roberts is not a corroborating witness for you. You understand that? You just said that.
Yes, Carrie, I don't believe heard it. She was sent off.
So it's your word and your word only, Ms. McCabe, that my client demanded a Google search. Is that right?
Yes. Yes. Mm-hmm.
Did you ever say that you actually heard that statement about that Google search? And you said no.
Correct.
The question that was posed to you by Mr. Lally was, what, if anything, did she, Miss Reed, ask Miss McCabe while they were sitting in the back of the cruiser that you heard?
Right.
Correct?
I misunderstood the question.
And you misunderstood that question?
Yes.
What
I
did you
did.
misunderstand about that question?
I didn't know it was that you heard, so I was explaining what happened in the back of the car.
I see. So you just ignored the part, literally, the part of the question where he said, what did you hear her say? That's what your testimony is now?
The word was heard, and I didn't hear it. I obviously got the question wrong because I did not hear anybody ask about a Google search.
Well, I know that's what you're saying now. I get that. But when you were asked, what, if anything, did she ask Miss McCabe while they were sitting in the back of the cruiser that you heard, your immediate answer was, at one point, she asked her to Google hypothermia and how long dash Google hypothermia, end quote. Correct?
Correct.
That was your answer.
Yes.
Correct?
To a question I misunderstood.
And that was a false statement, wasn't it?
Technically.
Technically?
Yes,
It's like being a
technically.
little bit pregnant, Ms. Roberts.
Okay, so remember, jurors, I said earlier, comments of counsel are not evidence and you're to disregard them. Ask a question.
Thank you, Your Honor. What do you mean technically?
Technically, I was under oath, and I did not hear Karen asked Jen to Google it.
And yet under oath...
But I knew it happened at that
and
time.
yet under oath you said you did.
Correct.
And that was a lie, correct?
Objection.
Was that a lie? Did you lie?
I did not intentionally.
But you did.
And
Not intentionally.
okay, that's the end of
Understood
this.
the question, Mr. Jackson.
All right. Is there any other question, or was that it?
I didn't hear what she just said.
I said I misunderstood the question, Mr. Jackson.
That's what you're saying now, correct?
That's what happened.
All right.
Can I ask one more question?
Okay.
In that quote, you said, at one point she asked her to Google hypothermia and how long. Then you corrected yourself and finished with Google hypothermia. What did you mean by how long? What were you about to say?
I don't recall.
Had someone told you something about a phrase that started with how long?
I don't recall.
Hypothermia?
I don't recall.
Like, for instance, how long to die in cold?
I don't recall.
Okay. All right, Ms. McCabe. I'm sorry, Ms. Roberts, you're upset.
Thank you.
100%.
You will be walking back in for the civil trial, returning to the Coliseum. I mean, literally, it was such a scene there with that crowd. Those guys are behind you, and you have a guy named Mark Diller, who is the lawyer that's in front of you. I wondered, what's his deal? He's a personal injury guy. Is he better than Jacoby and Myers? Is he a Sweet James? Is he a Larry Parker? I don't know, but I went to his website. I found his video. Let's take a look at opposing counsel and see what we think. Steve, you got him?
My name is Mark Diller. I'm a plaintiff's personal injury trial lawyer. I'm exposed to hardships of my clients, and I understand their struggles, and it gives me a level of appreciation for how valuable life is.
Beautiful vanity shot there.
My father is a first-generation American. His parents survived the Holocaust and came here at the end of the Second World War.
Okay, that's
When
enough
they
of him.
came here,
That's your guy, Mark Diller, right there. Do you know anything about him?
Nothing.
Nothing.
I mean, I know that he's a PI lawyer, which means he's after money. That's it. He doesn't care about justice. He doesn't care about who's
And he's
right
going to
or
get
wrong.
paid. I mean, it's something.
Yeah, I'm guessing. I'm guessing he's going to get paid something, or that's what his hope is. But he's not going to get paid by Karen.
No, he's not.
So,
other latest news: Kelly Dever. You said Dever, and you were right because it would be two V's if it was Dever,
right? The difference between Eddie and Edie, right?
You were right
come
calling
on.
her.
Yeah.
You should have said, you know what, ma'am? Actually, no, that is not your last name. Your last name is Dever. But anyway, Kelly Dever, who originally stated she saw Brian Higgins and Canton Police Chief Kenneth Berkowitz suspiciously surrounding Karen's Lexus SUV in the Canton Police garage called Sallyport, then later called it a false memory under your cross. She resigned from the Boston Police Department on September 1st. She was on medical leave or family leave or whatever all summer long. What are your feelings about her today? Do you have any, like, sort of, I don't know, sympathy for, it's kind of a sad character.
Sympathy.
Her whole life, she's so young and she's just got any? Or is she?
Zero.
No
sympathy whatsoever. She's also a grown woman. Young, I don't care. She's grown.
Certainly rude.
She was old enough to carry a gun. She was old enough to carry a badge. She was old enough to take an oath, right?
Yeah.
Those things come with consequences, right? You've got responsibilities. And look, I take no pleasure in, I'm not going to dance on her demise, but do I have sympathy for her? No. She made her bed, as the old saying goes, and she's got to lie in it. So I think it's exactly what should have happened, did happen. She should not ever carry a gun, carry a badge, be in a position of authority, running herd over the community. It comes with consequences.
Did you observe anything unusual that stood out in your mind that occurred, pardon me, in the Sallyport while you were on that shift?
So we've discussed this previously. I can't make that statement on the stand because I've been provided information released by the defense that it was not a memory, that it was a distorted memory. Therefore, I can't state it because at this point it would be a lie. I cannot make that statement that you're wanting me to make on the stand because I've advised that that would be a lie.
Ms. Dever, I've never asked you to make a statement one way or the other on the stand. I'm asking you an open-ended question.
Okay,
Did
so
you,
prior to
let me
the
ask
first-
the question. Did you observe something in the Sallyport garage on January 29th, 2022 that you found unusual, that stuck out in your mind?
Given factual information that makes it so I know I did not, no.
So the answer is no.
Correct.
Do you remember being interviewed on August 9th, 2023?
I do.
That was by a separate law enforcement agency, correct?
Yes.
Two separate law enforcement agents, is that right?
Yes.
And you were advised during the course of that interview on August 29th of something, correct?
Can you rephrase
I'm sorry,
that?
August 9th.
So what was I advised of? Can you rephrase that?
Sure. Were you advised that lying to those officers would be a crime?
So it was a willing conversation. I've spoken with their legal team. Because of the fact I was providing factual information that showed a statement of mine was a false memory, it was not a lie. Therefore, I made it in good faith, and I retracted given information that it could not be accurate.
Ms. Dever, did you understand my question?
Yes, I did. You threatened to charge me with perjury during our phone call prior to the first trial if I didn't lie on the stand right now. I'm telling you, I did not see anything. Factually, I've been provided evidence by a timeline that it is not correct.
Ms. Dever, my question was this. Were you advised that it was a crime to lie to those law enforcement agents? Yes or no?
No.
They never told you, they never admonished you that it would be a crime to lie to them?
Objection. Sustained. As to form, Mr. Jackson.
Sure. Did they advise you of anything? Any consequences of lying to them?
So we had a willing conversation.
Yes or no?
I don't recall.
Okay, there's your answer.
You don't recall if they advised you of anything?
No, because it wasn't.
As a trained law enforcement agent.
Go ahead and ask a question, but both of you only one at a time, okay?
As a trained law enforcement officer, are you aware that it's a crime to lie to certain other law enforcement agents?
When you have intent to lie, yes.
Okay. So you knew that when you spoke to these law enforcement officers, correct?
Yes.
Did you tell these law enforcement officers that you, in fact, saw Brian Higgins and Chief Berkowitz go into the Sallyport with the SUV? May I finish my question?
You can finish this question. Go ahead.
Did you tell those law enforcement agents on August 9th, 2023, that you saw Brian Higgins and Chief Berkowitz go into the Sallyport together and alone with the SUV for a wildly long time?
That was my recollection at the time.
So you did say that?
At the time, that is what I recollected.
Okay. You and I spoke along with Mr. Yannetti and Ms. Little on a conference call last year sometime. You remember that?
Yes.
Between the time that you were interviewed on August 9th, 2023, and when we spoke sometime in maybe it was April or so of last year, does that sound about right?
Yes.
Did you have any conversation with any other party about your potential involvement in this case?
No.
Did you have a conversation with anybody in the commissioner's office at Boston Police Department?
Not about anything malicious.
I didn't use the word malicious. Why do you say malicious?
I had a conversation, but it was my department saying, regardless of what I need to say on the stand, they support me.
You were asked to go to the commissioner's office, correct?
Yes.
How long had you been on the Boston Police Department at the time that you were invited to go up to the Commissioner Michael Proctor's office?
It had to have been before the first trial, so... And I know it was when the agency released information to outside people.
That's not my question.
Okay, so I don't recall.
Okay. You don't recall how long you had been on the force, generally, at the time that you were called up to the Commissioner's office, on the Boston Police Department?
No.
Was it 5 years, 2 years, 2 months? Give me a ballpark.
So I've been on the department for 2 years and 2 months. I would say somewhere in the range of a year.
Okay. Did you find it unusual for would you call yourself a rookie back then?
Yes.
Did you find it unusual that a rookie police officer would be called up to the commissioner's office personally?
It was a reflection of how good of a leader he is. It was not anything that I found unusual, given the fact he is someone who wanted to show support for his officer.
So I'm guessing all of your training class or all of your entry classes in Boston PD, they've all gone up to the commissioner's office as well?
I don't know anyone else who's been in this particular circumstance.
Do you know anybody else who's been called up to the commissioner's office at your level at Boston Police Department?
Objection. Sustained.
Do you know of any of your colleagues with your level of experience that have been called up to the commissioner's office for a specific instance?
Objection. That's sustained.
Now, when you went up to the commissioner's office, did you respond to his indication that he wanted to see you up in his office?
It wasn't a direct line of contact from him.
Okay. Did you respond? Did you ultimately go? That's what I mean by respond. Did you go to his office?
He's my boss, so yes.
Okay. And who else was in that office?
Me and him. The two of us.
General counsel of the Boston Police Department?
No, it's just me and him.
During the conversation that we had last year, did you say that general legal counsel for the Boston Police Department was also there?
Objection.
Not during that conversation.
Objection. Next question.
Sure. Was there another time that you went to the commissioner's office where general legal counsel was there?
No.
Have you ever met general legal counsel for the Boston Police Department?
Yes.
Was it in the commissioner's office?
No.
When was it?
During my conversation with the agents.
You took a lawyer with you to talk to this other law enforcement agency?
I'm going to see your type on this.
At some point, did the commissioner say to you that Boston Police Department, insofar as your connection to this case is concerned, Boston Police Department fully supports you?
Yes.
Did he also say, do the right thing?
That's a direct quote, so I can't recollect if he said a direct quote 2 years ago.
A year ago, when you talked to us, the defense, did you tell the defense that when you were called up to the commissioner's office, he told you two things? Commissioner Cox told you, number one, the Boston Police Department supports you, and Officer Deaver, do the right thing.
So he said my name correctly. He said Dever, And
That's not a mistake. Let's see. Like, you want me to repeat the question so I get
So,
right?
Mr. Jackson, let's go ahead and answer, please.
yes, and he said nothing with the intent of guiding me one way or the
I
other.
asked you what his intent was, madam. I asked you what he said to you. What were his words to you?
That he supports me.
And?
Just wanted me to tell the truth up here.
And his words were, do the right thing, right?
I don't recall.
A male voice on that phone call threatened to charge you with perjury?
Yes.
You're a police officer, correct?
Yes.
Who charges people with crimes?
If a crime is committed, there can be a report of it.
Who
So
charges people with crimes?
in the end, it's going to go through the court system. So the district attorney, the ADAs, that's who pursues it in a court setting.
Have you ever seen a defense attorney charge anybody with a crime?
So you can seek out reporting someone for it.
Have you ever seen a defense attorney charge someone with a crime, ma'am?
Personally, no.
Right. The fact of the matter is, nobody ever threatened you with perjury, did they?
Oh, they did. Yes.
That's it.
I contacted the FBI regarding it.
Oh, did you?
I did.
You have a report?
I have an email conversation where I sent the 2 questions I had. She responded, I will pass these along. I was contacted by their legal team. They reassured me perjury was not applicable because I made a statement in good faith. Upon further information, I retracted it, corrected it, and made it clear that I could no longer say it because I knew that it was not a clear reflection of the events that took place.
That's a mouthful.
Yes.
My question is, do you have a report from the FBI saying that you reported that someone on the Pyramid defense team threatened to charge you, your words, with perjury? You have a report to that effect?
No.
No. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hosslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own. You noticed when Mr. O'Keefe was placed on the gurney in a prior clip and moved past you, correct?
Yes.
Did you notice what your reaction was when that gurney passed you?
I didn't know.
Did you see that you turned your back completely to Mr. O'Keefe as he passed by?
If that happened, it wasn't on purpose.
Ms. McCabe, when you got to the scene, we can take that down. When you got to the scene at 6:03 in the morning, you immediately recognized, did you not, that this was an emergency situation? High-intensity emergency situation, correct?
I knew it was an emergency situation, yes.
As a matter of fact, a man's life was in grave danger. You knew that.
Yes, I did.
And this is someone that was a friend of yours, correct?
Yes, he was a dear friend.
Not just a friend, but a police officer who was laying, as far as you knew, dying in the snow. Is that right?
Yes.
You knew that you needed to get immediate medical attention, emergency medical attention to him as quickly as you possibly could. Is that right?
Yes.
You knew that minutes counted, right?
Yes.
You knew that seconds counted, correct?
Correct.
This man was grasping, as far as you knew, grasping and clinging to life at that moment. Is that right?
Yes.
That's why you called 911, to get emergency personnel who are trained in CPR and life-saving measures to the scene, to the gentleman, to Mr. O'Keefe, as quickly as you possibly could, correct?
Yes.
You called 911 at about 6:03 and 35 seconds. Is that right? I don't expect you to know down to the second, but it was about a couple of minutes after 6.
Right after, yeah, we found him, yes.
And you're aware from the dash cam that Officer Sheriff got there about 6:10. almost on the nose, right?
I didn't pay attention to the time.
You'll agree with me that there was about 6.5 minutes or so between the time you called 911 and the time Officer Seraph got there. Is that right?
If that's what the dash cam says, yes.
On that 911 call, you referred to John O'Keefe as a man passed out in the snow.
Yes.
You didn't say, this is my friend.
I needed to get, like you said, emergency there. So I wasn't going to give I wasn't going to give a description and say my friend is in the snow. I was going to give them the information that I thought was the most important at the time.
Did you say his name?
I just said a man because that was the most important identifying.
You didn't say John?
Eventually in the 911, I do say his name.
You didn't initially say O'Keefe, correct?
No, none of that matters. It was a man in the snow, and I wanted help there.
And you didn't say he's a Boston police officer or an off-duty police officer?
Again, a man needed help.
Yes or no? Did you say that?
I didn't.
Do you think that might, yes or no, do you think that might have sped things up if they knew, if the 911 operator knew that this was a fallen officer, a fellow officer?
I think 911 comes to everyone equally. I don't think they would have.
Do you think that might have been something important to relay to the 911 officials?
I don't know.
You even asked by the 911 operator, does anybody know CPR? And your answer was no, correct?
I'd have to listen to it to remember my exact answers.
But it was basically in the negative. No, we're not professionals. We're just out here doing the best we can, correct?
I wouldn't say that, no.
You didn't believe Karen Reed knew CPR?
I didn't know. I don't think I answered that question. I don't think it was asked.
You didn't know if Carrie Roberts knew CPR, correct?
I didn't know if they knew CPR, correct.
And none of you were paramedics?
No.
None of you are first responders?
No.
None of you are trained in emergency life-saving techniques in any way, correct?
Correct.
I have a question, Ms. McCabe. Mm-hmm. On all of Fairview, the entire road between Chapman and Cedar Crest, can you think of any person on that road who might have had life-saving techniques trained incident? First responder, someone who knew how to deal with someone in distress, someone with high skill level training. Do you think of anyone on Fairview who had that kind of training?
Can I now or did I then? Which are you asking?
Did you then?
No, then my focus was on John O'Keefe.
Okay, let me narrow the focus. How about on the property? How about at 34 Fairview? Could you think of anyone that was a first responder who would have life-saving training, life-saving technique training under his belt?
Yes, my brother-in-law, Brian Albert.
And you didn't go in the house, did you?
No, I did not.
When you arrived at the scene, you didn't go in? Not until much later, correct?
Our focus was John.
You knew that Brian Albert was inside the house. You'd just been with him hours earlier, correct?
Yes.
You knew that his window was 30 feet away. You're staring at it. You could look at it if you wanted to, correct?
It's off to an angle.
And you didn't go in the house then either?
I did not know.
You knew that John O'Keefe was clinging to life during those precious minutes and seconds. Is that right?
I did, yes.
And you also knew that Brian Albert, your brother-in-law, was a first responder trained to deal with people in that kind of distress, correct?
In that moment, my only thoughts were John and everything we could do for John.
And you knew that there were warm blankets inside the house. Is that right?
I did, yes. There were warm blankets in the house.
And you still never went in, did you?
No, I went and attended to John because once I finished calling 911, I went over to John and Carrie Roberts asked me to take over compressions. So I felt like that was more important and 911 was on the way. I never thought about going in the house. I just thought, how can I help John?
You never thought about going in the house, but you did pull out your cell phone and make 2 phone calls, didn't you?
After I called 911, I tried calling my sister, yes.
While John was out in the cold, clinging to life, you weren't doing chest compressions at 6:07 and 6:08, were you?
I was walking over when I was calling.
You were calling your sister on the phone, weren't you, Mr. Day?
I was calling them to see if they would come out, but I was going right over to work on him.
And you could have walked 25 feet to the front door, walked in the house, and screamed for Brian Albert to come out and help you in those precious seconds and minutes, couldn't you?
That would have taken me away from helping John, getting Carrie blankets, giving him compressions.
And making those 2 very important phone calls at 6:07 and 6:08 that you say were not answered.
They were not important phone calls. I tried to call my sister, and then I focused on John.
They were not important phone calls, but they were important enough for you to make while John is clinging to life right there in front of you, right?
As I was walking over, I called to see if she would answer.
And she didn't answer. Let's talk about that. She didn't answer according to you.
So if we're going to talk about it, we're beyond the luncheon break?
Your Honor, I have 2 more questions.
Okay.
And I'll wrap it.
Okay.
Let's talk about that real quick.
Sure.
She didn't answer the phone, did she?
No, she didn't.
So you have a situation where a man is laying dead or dying in the front yard of your sister's house. You see nothing in terms of life inside the house. Lights aren't coming on. They're not getting up. They're certainly not coming outside, right?
They were sound asleep.
They weren't coming outside, were they?
Because they were asleep.
You didn't know if they were asleep. All you knew was there was a severely injured man on the front lawn of their house, and your sister didn't answer the phone, not once, but twice, correct?
Correct, she didn't answer the phone.
Did you think your sister might have been in peril? Did you think to go inside the house and check that they're okay?
I had no reason to think that they weren't okay.
You had no reason to believe they weren't okay. The man was dead or dying on their lawn, and your sister's not answering the phone. And nobody is coming out to the chaos of Karen Reed screaming on the front lawn. You didn't think there was some reason to believe they could have been in peril?
I didn't, because your client was screaming she hit him. She had a cracked taillight. She was crying she hit him. I didn't, but my focus... Can I finish, please?
You had solved the crime right then and there. You solved the whole case.
No, I didn't. I knew John never came in the house, so I had no concern for anyone's safety inside the house.
The reason you didn't go inside the house is because you knew better. You knew better. You knew she wasn't in peril. You knew that Brian Albert wasn't in peril. You weren't worried at all about them, were you?
I was not worried at all because something happened on the front lawn that had nothing to do with anything inside that house.
You weren't worried about them at all because you knew what really happened, didn't you?
At that moment, I didn't know that he was hit by a vehicle and there was taillight found next to him.
All right, jurors, luncheon break.
So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Reed. The truth is, Karen Reed is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Reed because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Reed. Not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Reed of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel, through your verdict, that justice cannot be bent and that it will not be buried. Find Karen Reed not guilty, not guilty, not guilty. Thank you.
I put you on a pretty list. I'm gonna make you pay for this. Yeah, your AJ's dangerous. Ooh, oh baby, I was born for this.
Yeah, I brought the West Coast to Dedham. Nobody is safe from my verbal venom. Put a witness on the stand and watch me shred 'em. Have 'em praying for peace, like the name John Lennon. A lawyer to match me? Well, I ain't met 'em. Don't believe me? Just ask Hank Brennan. Free Karen Reed, and that was just the beginning. I'm never tired of winning. Got these middle-aged women waiting up to go swimming. Let's swim. I don't get nervous. I make people nervous. I don't get nervous. I make people nervous. I put you on a ready list. I'm gonna make you pay for this. Oh, and AJ's dangerous. Ooh, I put you on a ready list. Oh, sorry, Paul Pierce, Ray Allen, and KG, the real big threes. You Nettie, Bob, and me. Gonna come with the seat. Don't try me, you should know by now I always come with receipts. I'm out here penning letters like my name better roll. You got problems, Cox, and I think they're federal. Attorney Corey Hopkins, sure let them know. This ain't an episode, this a whole damn show. I don't get nervous, I make people nervous. I don't get nervous, I make people nervous. Ajax out here eliminating all you greasy motherfuckers. Ha ha ha. I'll put you on a Brady list. I'm gonna make you pay for this. Oh, yeah, AJ's dangerous. Ooh.
I'll put you on a Brady list. Oh.
All right, class. Today we're gonna learn how to do accident reconstruction. Does that sound fun? Well, listen up, cause here's how it's done. First thing to do is cosplay as the victim. You gotta buy his sweater, his shoes, and then some. His boxers, his shirt, and his denim. You all look confused. Did I say something wrong? I really need you all to play along. See, I don't have much evidence to work with, so I gotta half-ass it. It won't be perfect. Do me a favor, bring that bucket over here. Well, I was lost, but now I have an idea. You gotta paint your arm blue. What does that prove? I don't got a clue, and neither do you. Could have been a doctor, but I paint my arm blue. Yo, yeah, could have been a doctor, but I paint my arm blue. Alright, next thing up, I need some elbow grease. Yeah. We're gonna send this Lexus up to outer space, cause Hank Brennan won't give me any x-rays. There is no evidence, what do I do? Well, I guess I gotta paint my arm blue. You gotta paint your arm blue. What does that prove? I don't got a clue, and neither do you. That could have been a doctor, but I paint my arm blue. Yo, yeah, could have been a doctor, but I paint my arm blue. 400,000, thank you.
Called you up into my office. Got you flowers and some chocolate. I don't really do this often, but I think we need some talking. First off, is it Deva or Diva? I think I have liver fever, but before we take this deeper, I need to know if you're a keeper. What did you see in the salad pot? Are you sure it's something you need to report? I got an idea, I hope you agree. How about you blame it on a false memory? When the feds came, why did you sing? You should've knew better and gave me your ring. Know this and know this only before you go and give your testimony. Officer Deva, do the right thing. Do the right thing. Oh, do the right thing. Do the right thing. Oh, do the right thing. Don't get it twisted, this ain't a bribe, but if you tell the truth, there goes that 9 to 5. No more 6-figure salary. If you say what you saw on that Sally Port screen, I have your back. Unless they ask me some questions, I'll have your back. Until I throw you under the bus, I'll have your back. Let this be a lesson, I'll have your back. Really means I won't have your back. When the feds came, why did you sing? You should've knew better and gave me your ring. Know this and know this only before you go and give your testimony. Officer Deva, do the right thing. Do the right thing. Oh, do the right thing. Do the right thing. Oh, do the right thing. Unfortunately, Kelly, you're the only one going down. There won't be a public records lawsuit that'll expose me
or anything.
I've been biting my tongue for so long. Fuck you, Hank. Think you're better than me? Fuck you, Hank. You are not lolly. Fuck you, Hank. Think you're better than me? Fuck you, Hank. Well, why don't we see? I'm a basic kind of guy, I really don't need a flaunt. Smoking 6 packs a day and I'm happy as a hog. All I do is mumble, do I really need any lungs? The trial 1 jury was just like me, they were hung. Trial 2 came around and you wanna bench me? Not one guilty vote was embarrassing to see. Need to remind you that my jury was 9-3. Take your little OUI and get about the scene. Fuck you, Hank, Hank. Think you're better than me? Fuck you, Hank. You are not lolly. Fuck you, Hank. Think you're better than me? Fuck you, Hank. Well, why don't we see? Oh, I know what will get us the win. Ask Retrial about his fucking ham sandwich again. That'll prove this beyond all reasonable doubt. Oh, who am I kidding? This shit is a rout. You took this case so damn personally, and I hold that opinion to a scientific certainty. You weasel face, fuck bet, Arca Major P. Even with all the help you got from Beverly. Standing ovation. What a robust cross. Psych. Your nerdy ass looks so fucking lost. Just think, $500,000 was all it cost to get our asses kicked in the fucking law. Fuck you, hey, hey. Think you're better than me? Fuck you, hey. You are not lolly. Fuck you, hey. Think you're better than me? Fuck you, hey. Well, why don't we see? Hey. Waiting for your response, Becky.
I love you more. I love you more. This is like a love fest over here. It's like a love fest. And when they come in and they try and hate on our love fest, we have to bite back. We have to.